minister is the political head or the executive authority of that department at this point in time. So the fact that the report may have been produced before his time is immaterial. What matters is that he is accountable now as the executive authority of that particular department, and he should comply with the directives of the public protector in this regard.
So give us a bit more detail. What exactly did the minister fail to do?
The Office of the Public Protector has been interacting with the Department of Health regarding this investigation for a while now. There has been some exchange of correspondence where the department furnished the public protector with certain information in relation to the investigation, but the information was deemed inadequate. At that point, the public protector then served a subpoena on the minister, requesting him to present himself before her for purposes of answering questions in relation to this particular report. And as you have rightfully indicated, the minister has been served with subpoenas about the same matter on 3 occasions, first in March, then April, and then in May, for appearance at the beginning of this particular month. But on all those occasions, the minister could not show up, and each time we inquired, his office would advise that he was not available or he was held up with this and that. And the public protector felt that this is not on, because if you study the public protector Act, you will note that it makes it clear that where there is an investigation, no person shall do anything which, if the first investigation had been proceedings in a court of law, would have constituted contempt of court. And just for people to understand what this subpoena means, I would make an example of proceedings that have been taking place before the General Commission, where the Commission will issue a summons which is similar to a subpoena. And then when those who were summoned to appear before the Commission failed to do so, the Commission took things further and instituted contempt proceedings. It's a very similar thing.
If you could, Mr. Segalwe, give us perhaps some details about the recommendations of the Clinical Associates Task Team report that were meant to be implemented.
Just in a nutshell, the public protector received a complaint from a certain Mr. Simon Ngobo, who is himself a clinical associate and is a general secretary of a body called the Professional Association of Clinical Associates of South Africa, or PACASA. And he wants the Department of Health to implement the recommendation of this task team report. And just in a nutshell, that report touches on the working conditions of clinical associates. And clinical associates are mid-level healthcare workers who operate under the supervision of medical doctors, and their work is to care for patients, particularly in disadvantaged and rural communities. And they are a relatively new addition to our health system. The first cohort of such people called clinical associates having started working in the industry as far as 2011, January 2011. So it transpired that over time, certain difficulties regarding their working conditions were discovered, and that information is contained in that report. Unfortunately, according to the complainant, that report is gathering that somewhere is not being implemented. So the public protector needed the minister to come forward and provide reasons as to why this report has not been implemented and what exactly are the intentions of the department with regard to that report, given the fact that the clinical associates seem to be unhappy with their working conditions.
Mr. Segalwe, if you could talk us through what the next steps will be now after the laying of the contempt charges.
Well, the office will lay the contempt proceedings with the police, and the police would have to investigate whether indeed the minister has been contemptuous to a public protector, and at the point of the conclusion of that investigation, then we have to hand over the docket to the prosecution authority, which will do its own assessment in terms of whether or not that is a winnable case, and then to the extent that they may be convinced that there's a case to answer, they may have the case enrolled in a court of law for a trial.
Now, moving on to other issues still pertaining, however, to Minister Mkhize, we've seen the DA just a short while ago laying charges in Cape Town against Minister Mkhize. We have been told by the SIU that they are investigating the Digital Vibes contract and Saga. Is this a case that you, as the Public Protector's Office, are also looking into?
At this point in time, the Public Protector is not investigating anything related to the Digital Vibes Saga, but we have been paying close attention to developments in that regard. We have seen all the news reports that have been published in respect of that matter, and we have also taken note of the fact that the SIU is halfway through its investigation in respect of that matter. And the Public Protector specifically has not been requested to investigate, or we have not received a complaint in that regard. I must make mention of the fact that we don't need to be requested to investigate, but at this point in time, the Public Protector has not looked into that particular matter. But I'm not ruling out the possibility of entering the fray at a later stage, having considered what other organs of state have covered and what they have not covered in respect of that particular case.
And what would determine whether or not the Public Protector's Office does take this case up?
Well, if we are approached, we will definitely have to look into that particular matter, but we wouldn't want to duplicate what has already been covered. We would look at what has not been covered by the various institutions and look into that. But also, we look at the powers that we have vis-a-vis the powers of other institutions such as the SIU. For instance, as you know, the SIU cannot make binding remedial action, and the SIU will investigate only what is in the terms of reference which are compiled by the executive. Whereas the Public Protector has the power to decide what to investigate and what not to investigate. So all of those things will inform the approach of the Public Protector should things come to that point, or should the Public Protector be required to intervene in this particular respect.
Mr. Segalwe, we'll leave it at that for this afternoon. Thank you very much for your time